Hey everyone, today we'll delve into a recent Singapore High Court decision in the case of 3D Infosystems and Voon. This case is a fascinating study on breaches of contract, duties of good faith, and conspiracy in a corporate setting. The plaintiff, 3D Infosystems Pte Ltd, specializes in IT systems integration. The first defendant, Mr. Voon, was a senior employee who later joined Sunway Digital Private Limited, the second defendant. Allegations included breaches of contractual duties, fraudulent misrepresentation, unlawful disclosure of confidential information, and conspiracy. These breaches allegedly caused significant harm to the plaintiff's business operations. The court had to assess damages across multiple claims, which were grouped into 9 heads. Let's break them down briefly. Number 1, misuse of employees for personal business under the guise of team building. Number 2, disclosure of business plans to the second defendant, Sunway. Number 3, solicitation of employees to join the second defendant. Number 4, disclosure of the plaintiff's internal manuals. Number 5, inducement of breaches of employment contracts. Number 6, losses related to specific projects of the plaintiff. Number 7, preparation of quotes using confidential information. Finally, participation in industry events and correspondence affecting the plaintiff. Each claim had its unique set of disputes, evidence, and arguments presented. Let's take a closer look at the first 3 claims to illustrate the legal dynamics. Claim number 1, misuse of employees. The plaintiff argued that Mr. Voon diverted employees to work for his personal business, Biscuit Juice Bar, causing a loss quantified by the salaries paid during this period. Voon argued that the team building exercise had some legitimate benefits and that the plaintiff's loss calculation was flawed. Claim number 2, disclosure of business plans. The plaintiff sought to recover profits earned by Mr. Voon through breach of confidence, calculated as a difference between his total remuneration and the value of legitimate work done. The defendant disputed the methodology, claiming his income was unrelated to any breach. Claim number 3, solicitation of employees. The plaintiff claimed substantial losses due to employee solicitation, citing headhunter fees and profit loss. The defendants argued that replacement costs were offset by salary savings and disputed the extent of profit loss. Now let's move on to the decision of the court. For the misuse of employees claim, the court awarded $38,212, accepting the plaintiff's methodology for loss calculation as reasonable. For the disclosure of business plans claim, the court ordered Voon to disgorge $185,904 in profits gained through the breach, rejecting his arguments about his legitimate earnings, fully accounting for his compensation. While the plaintiff failed to prove quantifiable profit loss for the solicitation of employees claim, the court granted a conventional award of $50,000 for the plaintiff's operational disruption and unquantifiable costs. Headhunter fees of $97,283 were also deemed recoverable. This case underscores critical lessons for both employers and employees. Number 1, employees in senior positions owe a duty of good faith and fidelity. Breaches can lead to a significant liability. Number 2, companies must safeguard confidential information with strict protocols. Number 3, the doctrine of disgorgement emphasizes the principle that one must not profit from wrongdoing. This case also highlights the interplay between contractual and equitable remedies, showcasing Singapore's robust approach to corporate malfeasance. To conclude, 3D Infosystems and Voon offers valuable insights into the importance of corporate integrity and legal accountability. Thanks for watching. Until next time, stay informed and stay empowered.